As we know, the change in transition from Trump to Biden is imminent, right? So with that, we're going to see a flourish of many changes in the immigration arena. And what I have prepared for you today are some highlights because we are working with survivors that are eligible for certain immigration benefits, but unfortunately, some of them are taking forever. So just if you could maybe help me out to see how many of you know about U visas. If you can raise your little hands, that'll be very helpful. Can you hear me?
Yes, we can hear you, Sonia.
All of a sudden, you guys disappear from my screen, so I don't know why. But can you tell me? I don't see anybody. Can you tell me, Jocelyn, how many? Do we have lots of hands going up?
We had like about 6 or 7 up.
Okay, perfect. So let me just give you an example of what I'm talking about to give you some context. During the prior administration, we started seeing a slowdown on processing of the cases. The U visas have nothing to do, the slowdown of the U visas have nothing to do per se with this administration, but a lot to do with the number of cases that we have and visas available each year. Only 10,000 visas are approved each year. And right now we are processing the U visas that were filed in the year 2016, So people have been waiting for 4 years to get their visas. Now we're seeing that we have a queue of 150,000 visas pending, and only 10,000 visas will be approved each year. So we are seeing survivors that file their remedies and are not going to be able perhaps to get any immigration relief for 10 years unless something changes. So that's just one example. And that's why I wanted to share what else is out there. What else can we do to help survivors to get stable with some sort of immigration status or some sort of immigration relief, employment authorization, right? So that's what I want to share with you. So, so any questions so far about this? And I don't know, this is a disaster, Jocelyn, because I cannot see anything other than my slides.
It might help you, Sonia, to click escape to see if that helps.
Okay. Okay. I'm normally pretty savvy with these things. This is the first time that this is happening to me. So, okay. Nope, I don't have any Zoom or anything in here.
Let me try to do something else here.
Okay, I think I'm back. I'm gonna stop touching buttons then, because I got you all back now. And maybe Jocelyn, you can help me with the information. Okay, so if we can go to the next slide, please. This PowerPoint is available to you, and I also have prepared some special editions of it's called Noticias en Movimiento. They're in Spanish, but they're also in English. And I hope that that can help you as well. So for the past 4 years, we've seen a number of changes that were done through the administration. It had nothing to do with new laws or with changes in the law. They were all done by regulations, opinions, policy memoranda, and informal policy changes. So we hope to see now changes in the future. And one of the things that President Biden elected has said is that from the get-go, as soon as he gets into the White House, he's going to revert all these bad changes that have been happening throughout these 4 years. So we're going to see a lot of cleaning of the house back to things that were in place before for survivors. If we can go to the next slide, please. So a lot of the things that we have seen, again, have been non-laws, no publish of new laws or changes in the law. And we hope that all these administrative actions can be changed. I'm going to be talking to specifically to what you are going to be seeing in the field. A lot of bad decisions came down on gender violence. How many of you are working with survivors of gender violence that have asylum cases pending? Anyone?
There is one hand raised.
Okay, so basically the administration and through the Attorney General's opinions have been gathering all the protections for asylum laws and from survivors of gender violence that had pending cases. We went from having really good case law and getting cases granted for victims of domestic violence and sexual assault that were requesting asylum to most of our cases being denied, 99% of the cases being denied. So we hope to see the reversal of those bad policies and decisions, and that all the work that you advocates have been doing for survivors to gain momentum and protections for the past 20 years, little by little, being recovered. So if you are working with a survivor, an immigrant survivor of gender violence with an asylum case pending, my advice is that you seek immediately help with legal representation. There are nonprofit organizations in the state of Iowa, Justice for Our Neighbors, Catholic Charities, American Foreign Service Committee, and other low bono attorneys that can work with your client, because if she is at the end of the case, appealing the case, and then taking advantage of future changes from the new administration may make the difference between her being deported or her having a chance to obtain relief and justice in the country. So if we can go to the next slide, please. So what the president has been discussing, the president-elect, I keep saying our new president has been proposing are things that I think could benefit also survivors that you're working with. Just because you have a client, a woman that has a U visa pending or an asylum application pending, doesn't mean that if there is anything else available to her that she cannot file also for additional protections. Under immigration law, you can get as much, and apply for as many programs as they are available to you. So let me talk a little bit about DACA, because we work with a lot of young women that perhaps have been in here for a while. Please raise your little hand so I don't tell you things that you already know. If you know what the DACA program is and how it helps survivors or anyone for that matter.
I see you. 4, 5.
Can you repeat the question again?
Yes, the question is whether you are familiar with the DACA program and the requirements of the DACA program. Want to? Okay. Well, first of all, I have shared with Jocelyn information that is a bit more detailed in Spanish and in English. So feel free to read more about it. And I promise you it's not boring. It's just a couple of pages and it looks kind of like this. is very succinct and is targeting, just people in the community. So it's easy reading. So with the DACA program, people that have entered the country when they were younger than 16 years of age and were physically present in the country before June 15th of the year 2007, and they were younger than 31 years of age on June 15th of the year 2012, that have either graduated from high school or got the equivalent of high school or are now enrolled into high school, can file new applications, initial applications for the deferred adjudication of child earlyhood arrivals. What DACA does is protects people from deportation. It provides employment authorization for 2 years. And the proposal from Biden has been to expand, first of all, fully restore DACA, obviously, because we had some up and downs with the program to the point that we thought President Trump was going to make it disappear completely, as you may have heard throughout the many years of litigation. So fully restore DACA and also admit and get new applications. So what this means is if you have a client that entered the country before the year 2007 and she was a minor, maybe she qualifies for this alternative program. So you don't have to wait for your 10 years of U visa. And again, the good news is that you can have that DACA and still wait for your U visa until that comes to fruition or gets to the end. Questions about this point of DACA? All right, no questions. Okay.
I have a question.
Oh, go ahead.
You said enter in 2007, and they have to be younger than.
So,
last part.
So in June 15 of 2007, they have to be less than 16 years of age. Okay, so I put it in the chat. All right. Then they need to show that they were present on June 15 of 2012, and that at that time they were younger, right, than 31 years of age. So those are the basic requirements. Why do I say that those are the basic? Because you can always go today and start studying for your high school or the equivalent and then qualify for DACA, right? So review with your clients, with your immigrant survivors, if that is true for them. And again, there are people that will be doing legal clinics and free legal services. My office will be participating in free legal clinics, assisting people that don't have the means to pay for legal services to prepare these DACAs, okay? And those are good questions. Any other questions on this? Okay, excellent. So let's talk now about TPS. Who can tell me what TPS is?
Temporary employment, something like that, right? I don't remember that.
What was that?
That is a temporary permit for something. I don't remember the whole acronym.
All right, good. So it's basically temporary protected status. This is a special program for people that belong or come from certain countries that have been destroyed because of war or because of some climate change or natural disaster, like earthquakes, floods, etc. So it's a very special program. So what happened with the TPS is that, for some countries like El Salvador and Honduras, started in 2001, and people have been in the country for more than 19 years under these programs. When Trump, the administration, reviewed the TPS, they announced that they were going to destroy it and it was not going to be available anymore. We now know that that's not the case. We have a very recent decision from the Ninth Circuit where it is now solid. TPS will continue to be a program, and it helps, many countries, and it will allow people to renew their temporary protected status, to get their employment authorization for 2 years. And also a really nice change for Iowa is that if your client has TPS and she has a child that is a US citizen over 21 years of age, then this child can petition for the lawful permanent residency of the mother. So this is a very recent change due to some recent decisions from the court. So any questions on this? All right. So there are other proposed rules that are not yet final. One of the things that we're seeing again is that this administration that is about to end has been gathering and destroying anything that had to do with asylum protections, including now the new rule of having to pay $85 for biometrics if you get unemployment authorization under your asylum case, or not being eligible for employment authorization for a year if you're now requesting employment authorization and qualify under current laws, etc. So we are going to see some of these things being restored to the origin, to what it was before, and vacated. Another thing that I wanted to mention briefly is that we have had a lot of denials of U visas and VAWA cases and trafficking visas. We have had a lot of requests for further evidence, and where they were denying cases and doing nothing before, now they are taking those cases that are denied and bringing them to immigration court and start removal proceedings. So that practice is supposed to end, by which USCIS, which is the agency that provides benefits, immigration benefits, it's been acting more as a hostile enemy, trying to deny as much as possible, restored to being what they're supposed to be, an agency that provides benefits and opportunities for explanations and provision of evidence if something is missing. So if again you have survivor now with a pending U visa case, or you're filing new petitions, we're gonna see a change from working with a hostile agency to more open to communicate with us. Let me give you an example. The Vermont Service Center, which is the agency that seeks overall all these U visas and VAWA cases and T visas, since the inception of the agency, had been meeting with us advocates and attorneys in the field at least one time or 2 times a year to listen to our concerns, hold the stakeholder meetings, see how we could work together. Under this administration, those meetings were shut down, and we had not been able to have an open communication with the Vermont Service Center. We hope to see a change in the way the Vermont Service Center and USCIS is now working with us. If we can go to the next slide, please.
Sonia, I had a question before we move forward. And so the first one is, if there were any denials on U visas or VAWAs during the Trump administration, are survivors able to apply again under the Biden administration, maybe see a change in that, or what is your advice on that?
So there are rules for situations where your visa is denied. when your visa is denied, you have an opportunity to appeal that decision, by filing a motion to reconsider, a motion to reopen, or an appeal if you think that the administration or actually the service, the officer was really wrong in the decision. Um, so because there are these rules that are in books, if you have missed or your client missed that opportunity of responding to a request for further evidence, appealing or filing a motion, I would recommend to wait. If you pass your due date and the deadline, to wait to see if your client has the basis to refile again, because we're going to be seeing a more favorable decision making in the cases presented. I'm going to give you an example. Some of the requests for further evidence that we're receiving are capricious, hostile, and stupid. There are things that may be in the file already, or they're being truly difficult. They're like wrong requests for further evidence. People that are pro se don't know how to handle that, and they may have given up and gotten a denial. So I would recommend bringing your file to an attorney, volunteer. I do host a free legal clinic with Luna every Friday. I see people for free, and we take cases through the pilot program and other low bono programs that we have. So you can also bring your denials to Catholic Charities, Justice for Our Neighbors, American Foreign Service Committees, to see if under the new administration it makes sense to refile the case if you have missed the deadline of the 30 days for appeal.
Thank you. And I know that we had a couple of questions here in the chat box. I'm not sure if you are able to see the chat box.
I am seeing one right now, so I can answer if that's okay with you, because, anything that I'm going to say after this, there is one more thing that I want to mention about citizenship in a second, and then an announcement on the U visa. And then we can take as many questions as you want. I can explain to you anything from what is a U visa, VAWA, strategies to work with survivors. So if that's okay with you, Jocelyn, I'm just going to make the 2 points about the U visa and citizenship, and I'm going to be open to whatever the advocates want to talk about.
That works perfectly.
So the U visa, we recently got a really good decision from the Ninth Circuit that says that if your case has been filed and you have divorced and remarried, you can now include your spouse and your stepchildren into your petition. Or if you forgot to mention your children, you were fighting and then you were not sure where the children were, and now they show up, you can now include them in your U visa, even if the U visa has been filed. This is different because before, the cutoff for including derivatives was the time of the presentation of the application. So if you filed your U visa, you could not include anyone else. The change now after this decision from the Ninth Circuit is that even if your U visa has been filed and is pending, if you get a new spouse, a new partner, or new stepchildren, or a child of yours that you never included, you can now include them. So that means that this is a good opportunity for you to review cases with women that you know have U visa pending, to see if maybe they want to include kids, spouses, etc. So that's one change. And the second change is a heads up. And this may not be something that you normally do, but if you're working with lawful permanent residents, which are people that have green cards, right? And they are eligible for citizenship, to become citizens, we are expecting a big change that we hope Biden can quash. And the change is that we're gonna go from 18 pages and a handful of questions to more than 100 questions in the application. And also a raise from $725 to pay for the application to $1,170. So they're gonna be mission impossible. They're gonna make mission impossible to become a U.S. citizen on purpose. They're trying to hold immigrants from enjoying all the rights of U.S. citizens. So if you have clients, that may be eligible for citizenships, we're gonna have a free legal citizenship clinic coming up in February. We hope that we don't see the change by then, or that perhaps the president has done away with that horrendous change that has been proposed. So those were the last two things that I wanted to mention. And now I'm open for any questions and brainstormings from the advocates. So we have one question in here, and it says, I have a survivor who is in college and not 30 years old. What is her chances for a U visa? Okay, so the U visa is an immigration remedy for survivors of certain crimes of violence. Not everybody qualifies. That have collaborated with law enforcement or prosecutors or judges in the investigation or the prosecution of their cases. Let me give you just a case of a really sad case that we had, where the police officer filed charges or pressed charges on behalf of a survivor and put the code of simple assaults and not domestic violence in the report. The case went on to the prosecutor and they pleaded to a simple assault. My client was a victim of domestic violence, but because of the wrong classification of the case as a simple assault and not a domestic assault, we were unable to present the application. So as you're seeing survivors, make sure that the police report is putting in there the right codes under, Iowa law section 708.2, domestic violence, sexual assault, and that is the correct, again, report with the correct code. That's one thing that you can do very well. So there is no age restriction. So if your client, Sumaya, if your client that is in college has been sexually assaulted, or or she was the victim of an attempted sexual assault and there was an investigation, then your client can be eligible for a U visa. There is no age restriction. They're gonna look at whether she collaborated in the investigation of the case and whether she was a crime of a specific crime that is protected under the U visa.
I'm sorry, I forgot to say she is DACA.
Okay, that's good. Oh, perfect. Yeah. So yes,
I mentioned U visa.
Yes, yes, Maya. Yes, she can be a DACA. She may be also having a family relative petition pending, and she can also have a U visa pending. Absolutely. Sometimes, as attorneys, I choose to do more than one or two remedies because, for instance, I may do a VAWA petition because those are resolved in 1 year, and I can get an employment authorization under that case. But my client made a claim of citizenship and I cannot make her a resident. Well, then I file the U visa at the same time because the U visa will forgive the claim of citizenship. So I grab the best of both programs and I file them at once. I stabilize my client with the employment authorization, and later on I get her to be a resident, waiving or forgiving that claim of citizenship. So the answer is yes, absolutely.
Thank you.
Rosa, Rosa says, I have a client that pressed charges against her abuser. When she went to the police to ask for the report, they told her they couldn't press charges against him because he completed the IPV program. Is there any way to deal with that? So I think you could hire an attorney that can subpoena the records, because your client absolutely has a right to make a report and absolutely has a right to get a copy of the report. And then if the prosecutor did not press charges, or actually did not prosecute the case, it doesn't matter. Because what matters for the U visa is whether you were the victim of a crime, you reported the crime, you collaborated with the investigation of the crime, and that's all you go on for the U visa. Then you have to go to those cops or to whoever is in charge and say, please certify that indeed my client was the victim of that crime and that she helped you. So we still need the signature of those cops that investigated the crime to move on with the case and present it to immigration, right? So that's what I would do. If you're an advocate, they love you guys. They hate attorneys. You know, I would go and talk to the officer supervisor and say, we just want a copy of the report that she made. That's it, okay? Rosa, I hope this is helpful. Then Hugh says, hi, Sonia. I have a question that may have been addressed earlier. I've heard that starting January 11, 2011, gender-based, in 2021, no, I imagine? Yeah, gender-based asylum will be eliminated. Our asylum applications in trouble. So two things. One, you cannot have a retroactive, a law that is going to damage cases retroactively. That's a constitutional violation of due process and other clauses that just, you know, top of my head that I can think of. So I don't believe that that will be applied retroactively because it will be challenged in court. Two, all these mambo jumbo, all this stuff that is being spewed, you know, out of the mouth of this current administration may be addressed with the next administration. So I will wait for Biden to, you know, be sworn in and see what is going to happen with the applications before I go into a crisis mode. I will tell my clients, and I'm telling my clients, hold on in there, we're not done. You know, you're gonna hear a lot of bad stuff. That doesn't mean that is the final thought or the final word. So that's my advice. Hold on in there. Let's see if by February 1st there are any changes instead of before Biden takes presidency, right? Okay. Let me see if we have more questions, Jocelyn. Do we have more questions right now from anybody? You can also open mic. I don't think we're too many, no? We can open.
Yes. I'm going to stop sharing the screen that we have up, and then you all can turn on your cameras, your mics to ask anything. Let me do that.
I have another question too, Sonia.
Absolutely.
It's about U visas.
Okay.
So, you know, we've heard from several pro bono attorneys that they won't even accept those cases because of the backlog. Are you still doing those cases? And I mean, how, what is your advice on someone who comes to us and they're not eligible for a VAWA self-petition, and it seems like it's either asylum or U visa? You know, like, yeah, like in general, that's my question about U visas. I'm perplexed about it.
Okay, so my heart breaks because it is true. So, you know, on one hand, we have a survivor with a perfect case. So what's the matter with you? Take the case, right? But on the other hand, as a lawyer and a business, a professional, and also being in relation and working with nonprofit organizations, I see the liability there. If we know that I'm presenting a case, and I'm not kidding you, that is gonna take maybe 10 years to be approved, I may not wanna be liable for whatever comes along my client with a U visa pending for 10 years. She may get into, you know, removal proceedings. She may commit some crimes. She may, I don't know, 1,000 ways that this can go. Then am I responsible for everything that my client does just because I help her do a U visa? So since I'm a for-profit, obviously law office, I bring them in, but this is what I'm doing, a couple of things. One, I am giving my clients a complete copy of their cases. Because what if I win the lottery? I don't know. I'm not gonna teach them. So here's the copy of your case, right? From the day one. Along with a copy of the case, I'm giving them a series of um, uh, uh, documents like change of address. If you move, you will always have to come to me so I can change your address. So that's the number one thing. Do not lose contact with me. We're gonna be, you know, on this relation for a long time. So I need to know your changes of phone number. I need to know your changes of address, because as an attorney, I have an obligation to tell immigration where is my client so she can be notified of any developments of the case. Also, on the first day of January, you know, we do attach to the case and we say, what's up? Anything new? We tell you, you know, they're getting the 2016 approved. You are 2020, you have a long way to go. Or you're 2017, you may have 2.5 to 3 more years until we get to you. So just that January push is helpful. The other thing that we're doing is emailing and providing electronic copy of the file. I don't know how many clients have come to me and said, my basement flooded and I missed and I lost all my papers, you know. So emailing, CD, so those are things that you can do. Here is one suggestion, and I'm not gonna, I can do that because I'm a private attorney, but you know, I think as a service provider, one of the questions for nonprofit organizations is, can we assist with a limited representation and say, we are going to represent you only, you know, to file the application. And after that filing of the application, you need to know that we're no longer going to be your attorneys. We will withdraw. There are some ethics involved in that, you know, but that's something that you guys have to explore to see if it's worth it, at least to have the help of that NGO doing the filing and then saying you're on your own for the next 10 years. If I'm an indigent client, that may make sense for me, you know, at least they get to file it.
Right. Okay. I think what we're experiencing is that ethical concern. These NGOs are saying, we can't do that, right? We don't know if we could be around in 10 years if we even have the same staff. So we are just going to not do U visas anymore. So that's what we're seeing a little bit more of.
Yeah. So I'm gonna push, okay, because that's who I am, right? Because I was NGO for 12 years, for 20 years actually, because then I did ASISA for another 8 years. So the push is, don't get so comfy. Don't choose what's easy, right? Figure it out. That's my push. So maybe you guys are awesome at pushing us, you know, attorneys, on things like this. So what about if you have clinics where you assist, you know, U visa applicants to prepare everything and you review it, and an attorney at least can sit down and see that everything is perfect and correct. And then if they don't want the liability of the 10 years, at least they will have the proof of a stamp to present the case. So that's one way of doing it. Another way of doing it is limited representation, contractual, saying, I'm gonna present your case when I get your notice of receipt, when I get your fingerprints done, you know, and everything is calm and perfect, I will withdraw my G28. And that's a commitment, right? So, I know that, for instance, back in the days when I was working with Luna and we didn't have the capacity, we were doing workshops where survivors will come and kind of like work with us separately to put their cases together, and then the attorney or myself will review the final product. So what I'm saying is, if you have a perfect case and you have the ability and the capacity to assist, you know, I think it's good to have a task force, sit down, get well-sounded legal advice, and continue. For crying out loud, continue. Because the U visa is not only a tool that helps eventually to gain final immigration status. It is also a tool for stopping a deportation. You can request a stay of removal if you have a T visa or a U visa, so they don't send you out. If immigration encounters you, you can request from the judge a continuance. That's heavily litigated right now. We hope that the courts will calm down with the new administration. So because of so many reasons, it is so impacting in the life of the survivors to have this done, that I will just, do a little call for the revolution, put together a committee task force and explore approaching NGOs that can continue doing the work, right? Or maybe the private bar, so we can also help, review those applications.
Thank you. I appreciate the perspective. Yeah. One more question, and then I'll shut up and allow other people to ask. Is it possible to apply for 2 different types of immigration application at once? So you visa and an asylum.
So I have had cases, and I said this before, where I had VAWA I-360 because I had my client married to a lawful permanent resident or married to a U.S. citizen or divorced within 2 years from an abusive lawful permanent resident or U.S. citizen, or was the mother of an abusive, son or daughter over 21. So I had clients with VAWA, perfect VAWA cases that perhaps left the country, left the country and re-enter, and that was not connected to the abuse. So I know under my VAWA self-petition that I can get my case approved, my I-360 approved, and that I can get employment authorization like within 14 months. That will stabilize my client, and she will be financially independent for the long-term survival of the abuse, will be helpful. But I cannot give her the residency through that program because of the inadmissibility ground of entering and re-entering. She has a permanent bar. Where do I go? Oh, I have the U visa. Okay, so let's file also the U visa, because eventually my client is going to have an employment authorization. She's going to be renewing, every year for the next 9 years, and eventually she will become a lawful permanent resident through that U visa. So yes, you can have someone in deportation proceedings that is doing an asylum, gender asylum, that is also a candidate for a U visa and for a VAWA self-petition. And I'm gonna throw one more in there as a, as a freebie for your tool bag. Maybe the child is in the military and is over 18 years old. There is a program called PIP, Parole in Place, for parents of sons and daughters over 18 that are in the active service, the military, and they can get parole and an employment authorization and eventually the residency. So I personally get super excited when I do an intake and I see the trunk and all the branches of all the stuff that we can do, right? Sometimes I may refer out to a nonprofit organization, the VAWA, and the visa, and I may keep the removal defense and maybe the PIP or any other programs.
You don't recommend that one attorney be responsible for all those applications, just to make sure that everything looks the same, like all the affidavits and.
Okay, so this is what I do when I work with other NGOs, because I know, again, that, I may do some things pro bono, some things low bono, and some things I charge. If I know that my client doesn't have the money to do all the things that I want to do, I collaborate with other lawyers. And it is my responsibility as an attorney to get a copy of the other attorney or to give my copy to the other attorney, so everything is perfect. And we are professionals, so it is our job to make sure that if she says, I entered the country on or about October of 2007, that is the date of entry for all of the forms and all of the forms of relief. So good collaboration, is something that can highly benefit the immigrant survivor that doesn't have the means to pay for everything, right?
I have a question.
Uh-huh.
So I have a client that she applied for U visa in 2016, but nobody told her that she could apply for VAWA. She is married to a U.S. citizen.
Okay.
And she applied for the U visa, but she haven't got any response yet. We already know why. So if it is possible for her to apply for VAWA, will be better for her to keep waiting.
You know, I'll tell you what. So we're getting approvals from February of 2016 right now. We are getting employment authorizations for, you know, all the cases that were in 2016 and now, I'm sorry, 2015, obviously those are approved or about to be approved. And then we're getting employment authorizations for people that are in the spring of 2016. She may be at the verge of getting the approval, but at the same time, if you look at the date and it's November of 2016, I would highly recommend you to do the I-360 VAWA self-petition because that may be faster than the U visa. And here's the other advantage. If she's married to a US citizen, you can do two things for her. The I-360 self-petition, ¿verdad? And then you can add the adjustment of status, which gives her an employment authorization within 5 months of the pendency of the case. And that will take her to the end, which is a lawful permanent residency, faster than if the U visa is approved. Why? Because when the U visa is approved, you have to have 3 years of continuous presence on that U visa for you to then request the lawful permanent residency, the green card. So if you do the math, it may be a lot faster to get the residency through the abuser US citizen than the U visa. Now, having said that, maybe she did not apply for the VAWA petition because whoever did her case saw in there that she cannot do the adjustment of status because she said, I'm a US citizen in paper, and there is a claim of citizenship or any other big problem or a prior deportation, right? So you need to look at why that VAWA wasn't presented. And if it was screwed up from the attorney, you know, because we're humans and we make mistakes, then maybe you want to review it.
Okay, so yeah, she applied, I think that was December of 2016, and she came here through the border. So I guess that's why they went with the U visa, because she had the inadmissibility. Oh my gosh, I can't pronounce that word. So I guess that was one of the issues.
No, because, you know, so if her visa was filed in December of 2016, I would explore again the VAWA. If she entered without permission, it doesn't matter because VAWA allows you to get your residency in the country. So that is automatically waived. What is not waived is if she's not married to him and she goes back and forth and she has a permanent bar, right? Then you can do the VAWA, but not the residency because you have that issue. And the U visa cleans that up for you. So the question is, can I get her employment authorization now? I would say go and file for the I-360 because if your client filed on December of 2016, it may be 2 years plus until she gets to get the U visa approved. So, and ultimately, you know, it's up to your client. You share the information, you answer questions, and then she can do whatever it fits, right? Fits her life and her choices. ¿Qué más preguntas? What other questions? We have about 4 minutes, right? I can be here with you guys all day long, you know? I don't even need coffee. What other questions? And again, they're not silly questions. Bring it on. If you have any doubts, you want to know about anything, even if it's not related to VAWA or U visa.
This one is more related to work visa. I'm sorry, Sonia. I have to take advantage of your time.
Get going. I'm good. Go.
So another of my clients, besides domestic violence piece, she also suffered violence in the workplace. Okay. She was assaulted by an American citizen in the workplace. When the police got there, the owner of the restaurant didn't want to give a copy of the video because he said that he was going to get in trouble because the American citizen make a threat and told him, I'm gonna accuse you that you have illegal people working here with you. So my client had to get hospitalized because she caused her internal bleeding.
Oh my gosh.
Yeah, it was like pretty rough. So when the police got there, they didn't want to cooperate. So again, there is no report. So I was like, is there any way to support my client? Because
yeah, so this is so a couple of ideas, right? When the crime occurs in the workplace, you have federal agencies in addition to the police. You have the EEOC, Equal Employment Opportunity Commission. You have the DOL, Department of Labor. You have Civil Rights Commission. So I would trigger, I will file a complaint with civil rights, and then I will take the testimony of my client and file a complaint with the EEOC as well and explore that, because maybe your client has been discriminated by the police, you know, and they failed to do the report and is related to her race or national origin. I don't know. I will take the medical records, you know, and I will also talk to the cops about a potential extortion charge, because if that customer threatened the owner with, you know, harm, it could be an extortion case. And extortion is one of the U visa crimes. So I know it may not be within your grant to cover this piece, you know, but you may be able to refer her to Justice for Our Neighbors. They're pretty savvy about where else, you know, to go with these cases. So, ¿qué más? What else? All right, so 1 minute. Just want to let you know, please, there are a lot of changes coming up. Would love to meet with you maybe at the end of January, tell you all about implementing some of the changes. You know, maybe for next round, we can have some of your questions before we meet, and I can tailor it to your needs. In the slides that I share with you at the end, I was prepared to get you all excited and thinking about activism and looking at your agency and seeing what do you need, you know, when these changes come down in your agency to assist survivors. Do you need more information? Do you need more funding? Do you need more staff? Do you need more collaboration and bringing people to the table so you can get more protections for survivors? You need to organize a private bar so they can take those U visas that no one wants to take, right? What is it that you need? Think about that, you know, as you're going away and you're breaking for Christmas or for the holiday, or you're going on vacation, and think about what would you like to have in your stocking, you know, this Christmas or these holidays or this break, you know, what is it that you're gonna need? And come back energized and ready to get the information and act on it. So my last slide that I prepared for you before we jumped into destroying the agenda and just like getting to your needs was about that, you know. I hope to be helpful to you and to be a resource to you in the future. And I appreciate the opportunity. So thank you so much.